Welcome to this video on the laws governing the arbitration. In the previous video, we told you that an arbitration is binding and final. Now, how does that happen? There's no judge involved, there's no court involved. So, how is it that a decision given by a third party is binding on the parties? Now, the answer to this lies in the Arbitration and Conciliation Act 1996. This is a legislation in India that governs arbitration. What it says importantly is exactly that a decision given by an arbitrator is final and binding. The Arbitration Conciliation Act also governs a number of other features. For instance, it restricts the role of courts in arbitration so that arbitration doesn't become an extension of the courts. It ensures that where there is an arbitration agreement, parties can only go to arbitration and cannot go to courts. It also ensures that the courts lend their support to the arbitration. So, it deals with elements such as appointment of arbitrators, the default arbitral procedure, the role of courts in arbitration, the result of an arbitration award, the manner in which the award is enforceable, etc. Now, these elements are captured in the Arbitration Conciliation Act. A number of these elements which are prescribed in the Act are not necessarily binding on the parties. They provide the default rule in case the parties don't agree to anything else. But in fact, the parties have the right to create a lot greater flexibility in the way they resolve their dispute. This they can do by either incorporating certain existing arbitration rules into their agreement or by devising their own set of rules. As to the former, there's a number of existing arbitration institutions across the world. For instance, the International Chamber of Commerce, the Singapore International Arbitration Center, the Mumbai International Arbitration Center, etc. Each of them have their own set of rules on how an arbitration is to be governed, and the parties can incorporate those rules into their arbitration. The parties can also leave that entire field open and allow the arbitrators to decide the procedure of an arbitration. The arbitrator, as recognized by the Arbitration Conciliation Act, has the power and the right to set the procedure of an arbitration. That is the inherent procedural flexibility that comes in with the choice of arbitration. This can cover a number of elements such as how should a party be informed of the arbitration? How do you conduct hearings? Do you need to be present in person or can you do it remotely? Do you do it on a documents only basis, etc. All of these elements we'll cover in a little bit more detail in the following videos. Suffice here to say that in addition to the Arbitration Conciliation Act, the procedural rules chosen by the parties and the tribunal or the arbitrator's determination of the rules also play an important role in deciding the rules of the arbitration. That is about the procedure of the arbitration. On the substance, there's a number of different laws that apply. For instance, if you have a contractual claim, someone says they owe you money and you need to decide whether or not that money is owed. That is what we call is the law governing the substance of the dispute. That law is maybe the Indian Contract Act, if it is a contractual dispute, or if it has something to do with property, the Transfer of Property Act, etc. Now, that is a altogether new world of laws that we will not be covering in this module. Another aspect that we should address here is the relevance of the procedural rules that apply to courts to arbitration. These are significantly the Code of Civil Procedure and the Indian Evidence Act. Now, both of these, which prescribe the procedures that need to be followed by courts, are not applicable to arbitration, and therefore we need not feel restricted by the procedures contained therein. We hope in this video you've gained some understanding of the relevant laws that apply to an arbitration.